It'll take me a little while to get my head around that.
Hey, right, guys. Just bear with me whilst I do the usual back office ticking boxes on YouTube. Just we're nearly there. Let's just pin that actually. Yeah, usual stuff, guys. So please. All right, let's just turn this off. Uh, that's one of the buttons. Yeah. So please don't share personal data in the chat. Ask questions as what if questions, as it so you home in on what it is you actually want to know about the law, rather than putting in your sensitive personal data all over the internet. Um, just bear with me a sec. There's one more thing I've got to do, which is this one here. Cool. Right. Yeah. Cool. So, yeah, there's not legal advice as well. Welcome back, Karis. Karis has been on her travels. Um, yeah, 6 questions coming through the week. I think all of them aren't anonymized. Oh no, there's what the fact there was one that's anonymized. So we'll start with that. Get into the live chat. See what questions are coming up there. But yeah, just kind of phrase questions. I mean, I'll put this one as an example. Just to see, try and explain what it is I'm talking about, because I appreciate it might seem a bit of a weird request, but there's a reason behind it. So, share document 2. So here we go. Yeah, hopefully you can all see that. Yeah, so what can be done when an MP just copy and paste the council's decision email in their response and doesn't want to help further? Now, obviously, that's almost certainly relating to the person's own individual situation. However, the way it's written is it doesn't actually kind of divulge that, which is helpful, and it also helps us kind of give an answer which is kind of extracts the legal bit rather than a load of other sort of distraction sort of stuff. And in answer to this question, because often we tell people that if they're up against it with a council, that involving an MP can be really helpful, and it can be, but obviously it does rely on the MP being decent. That's not always the case. So a good MP, or certainly a good MP staff, because it's often the staff who are actually running around doing stuff, they will first of all have a real grasp of housing law, which you would assume that they would anyway, because they deal with a lot of cases like this. And then they wouldn't just kind of take what the council's saying at face value, because any sensible person in the sector knows that councils get it wrong a good amount of the time. But in terms of what people can actually do, I would suggest if your MP is useless, keep going with the councillors, because MPs actually, although they might seem more authoritative, they're actually not when it comes to councils. It's the councillors which are within the organisation of the council which actually have more clout often. The MP can be helpful, but it's going to be the councillors that really define whether the council changes tack really. So keep going with the councillors, and if yeah, it might not work, but what you might be able to do is continue with the complaints process yourself, if assume you're going to get it upheld. And then if it was me, once I got it upheld, I'd go back to the MP's office and make a complaint about the MP and say, why didn't you just copy and paste the council's response when actually, the LGO or whoever say that they were acting unlawfully. So that's kind of something which was my thought about this. I don't know if you guys have got anything else to add to that, or experiences with MPs, but yeah, it's very dependent on who your MP is.
Can I just say, I find university with MPs, they're almost always basically do that. They'll write to the council send some letter back showing great respect for the MP, but often just saying that the client can get lost. And the MP forwards it and says, I do hope this helps. And that's it, full stop. There's only 2 MPs that I've ever really been impressed with. And one of them isn't an MP anymore. That's Karen Buck. And the other one is Siobhan McDonough. Karen Buck was Westminster North, and Siobhan McDonough, I think, is still the MP from Merton. And they're really good. They get involved and ask questions rather than just passing on the complaint and doing that. But I think maybe local councillors are more, have got a bit more energy because, I mean, I think MPs feel that they can't really. I've never quite understood with MPs this idea of MP as a caseworker. It's sort
Yeah,
of, I've never known many MPs that get involved in constituents' day-to-day problems. I mean, maybe I'm missing something. Um,
I think it must vary. I mean, I'm sure if you're in Clacton, you probably don't get a lot of casework done. But so Bedford, I've had a really good experience with the MP's office. Not necessarily the MP, but the two of their staff at least two of their staff are really cool. And I mean, a couple of the staff been on the training that we do. So kind of have an idea of what the law actually says. I've always been toying with the idea of making places free for elected people, elected officials, as a way of kind of getting information out there in a way that's going to be helpful. But I'll think about that some more. So yeah, how you watch on that? Yeah. So what else was I going to say? That's probably it.
I would also
Yeah.
add, just to go back to the MP and try and explain your version. I know it might seem a waste of time now, but while you're explaining to them and still going through the complaints procedure, you can explain it clearer to them. So, or request a meeting with them just to keep them involved. Although they've gone through it and we don't want to help anymore. Hope that helps. But if you go back to them and try and explain to them, and then if you complain about them later, and you can go to the parliamentary ombudsman, but you've explained why the council are wrong to him, so he's still aware of the situation. And if you get it upheld, you can then explain to him you were still wrong and you didn't help.
Yeah. Yeah. I think
I
that's.
think
I mean, sorry, Shannon, go on.
no, sorry, I was just gonna say like I went to a talk ages ago now. I think it was before sort of the general election, and there was an MP there saying like we get so many letters and emails. It's not that we don't care, but like if you want us to help, and it was around homelessness specifically, if you want us to help, like come tell us your story, like in person, make us feel emotional. And he said, like, he was like, I know this sounds like I'm being like really bad. I'm just being really honest. I put more effort into the cases where I've heard and met the person, I've heard their story, and I've connected with them in some way than just like 5 emails in a row that, you know, might be just as worthy. He's like, I just don't have that connection. Which I think is it's a difficult one to balance as well, isn't it? Because you shouldn't have to sort of put your whole life story out there to get your MP's help. But I also appreciate his point of like, well, actually, you know, black and white text doesn't have the same emotive effect. So yeah.
Yeah, cool. Thanks, Shannon. Yeah, I think particularly when I don't know, my experience with kind of people sort of sending emails and stuff is they often like dump like pages and pages of stuff there, and it's like you just need like a couple of lines to just kind of explain what the backstory is. But yeah, I think you're right, Shannon. Actually, kind of picking up the phone to them or going to an advice surgery, meeting them face to face is probably far more effective. But yeah, cool. Okay, well, that's the only question we've had in come through the week that was anonymized. So there's 5 more, and there's nothing in the live chat at the moment. I will say actually, I've got a couple of things to put out there. Appreciating that quite a few people watch this, like the recording rather than it live. And particularly as it's Halloween tonight. Happy Halloween, by the way. Got my Halloween mug out tonight. One of the things is I put a video up this week which was titled "Why do housing officers break the law so often?" And if you want to check it out and if you find it useful, then do share that one around. I wouldn't normally ask, but for me, it's kind of like probably I would argue it's kind of one of the most important messages out there at the moment for the homeless sector. Like no one wants to talk about it, and because no one wants to talk about it or acknowledge it, the algorithm or the kind of the stats on it are quite disappointing from the point of view of how far it's gone so far. So if you want to just as I say, if you feel inclined to share it about, doesn't matter what social media platform you do on or whatever, you've got various options, but it might just be a way of getting it out further. Because usually the people who would kind of like and share it, this one they're not liking or sharing it. I think because it just puts them in a bit of an awkward position. So yeah, that'd be helpful. And also just a question again, just you feel free to put a comment on this either in the live stream or later. Shannon was telling me about this kind of debate that's going on at the moment with whether charities should give tents to homeless people, and seems to be kind of various organisations are taking different kind of stances on it. But I'd just be interested to hear what people have got to say. Who watched the live stream, whatever. Is it what should charities do? Should they give tents out at all? Does it solve anything? How effective is it? But yeah, just be interesting to hear back because I think we're going to end up kind of recording something at our end as well, just kind of gathering a few people's perspectives on it. So yeah, I'll just keep on the live stream. Yeah. So yeah, just someone just making the point there that so having MP involved, it doesn't do any harm. It can kind of increase the amount of accountability on there sometimes. And it's probably more likely then to actually kind of be be kind of recorded, and it's more likely to be banded around in email. So it's very helpful for that reason. But anyway, so cool. Let's get to the questions that are coming through the week. And this, I hope this is going to make sense, because it's kind of part of a wider set of questions, but I think it does. So what can be done when the council has sent a rejection of homelessness application via email but won't provide a Section 184 letter despite several requests since over 2 weeks ago and several follow-ups? Is it still possible to ask for a Section 202 review within 21 days? So this actual question relates to someone with pre-settled status. So yeah, so someone who is has come to the country at some point in the last few years. I honestly don't understand it. I did a bit of Googling. I've sent my Google results to these guys, and we didn't have enough time really to kind of come up with any firm things. But basically, I think the question itself, or the kind of the idea of the question itself, would be helpful in other situations as well. So, but again, there might be a technical answer which I'm not aware of. So, basics. If we just go back to basics, you can make a homeless application simply by contacting any Department of Housing authority and asking for help with housing in some way, and giving the council reason to believe that you might be homeless or you might be threatened with homelessness. That triggers Section 184, and essentially, because you triggered that, you have to get a Section 184 letter at some point in the process. Now, it might not be a good one, but they have to give you a letter. And if, say, the council is going to come back and say, well, do you know what, we're satisfied you're not homeless, or we're satisfied you're not eligible, then they would still have to write that in a letter. They have to be like a not eligible decision, rather than just saying, oh, we're not going to accept the application at all. Now, there is a little bit of doubt I've got about that, because I remember some little bit of small print somewhere where it's not quite the same, but I think that's kind of how it should happen. And so where you've got a council which is literally just kind of refusing to take the application, which sounds what they're doing here, rather than accept it, yeah, basically they failed there. They would need to give a Section 184 letter which explains why that person is not eligible or is not homeless or whatever. Now, I'm looking at particularly Will and Karis here, because you guys are solicitors. Is my answer there on point, or is there something weird with eligibility which is different from other kind of parts of the 5-part test? Your blank faces are very reassuring.
No, I think you're right. I don't think there's anything different. I think it's basically unlawful. And if they are rejecting the homeless application, if they send an email saying, sorry, we're not going to accept a homeless application, that's an open goal for a judicial review or a formal complaint, I'd have thought, because they're perfectly entitled to reject the homeless application, but they have to do it through a Section 184 notice, which gives the statutory right of review, and that's true for eligibility as for anything else. So, to take the question a bit further, is it possible to ask for a Section 202 review within 21 days? And I would say no, it isn't possible to ask for a Section 202 review, because you can only have a Section 202 review where you've had a Section 184 decision. What you would want to do is send a letter in accordance with the pre-action protocol for judicial review proceedings saying you have unlawfully failed to process my homelessness application pursuant to Section 184, and I'm going to go to court if you don't process it. And I think it's the sort of thing a High Court judge would buy into, because it's just a clear breach of the procedure.
Yeah, I mean, I think that, so the LGO would also have a lot to say about it, but that would be much slower than getting the solicitor, getting judicial review. But yeah, that's reassured me in terms of that's how I think it would have to be dealt with. As you say, well, it's not, you don't know it was being dealt with differently from a normal, any other kind of any other homeless application. And the question becomes, I'll put the link into the chat actually. So there's a case which I saw summarised in Garden Court Chambers. I went to Shelter's account of it, then I went to Nearly Legal's account of it, and none of them kind of made it obvious to me. But essentially, it was a case earlier this year. It's called C versus Oldham, I believe. And basically, hold on a sec, let's just get the link. So basically, someone with pre-settled status was found to be eligible for homelessness assistance, which is kind of not what they were expecting. And it seems to be like kind of likely to get go to Court of Appeal and kind of potentially get reversed. But yeah, just kind of that was just, as I say, it was all news to me. I don't understand any of it really anyway. So it was kind of like yeah, all confusing. But there was just a case there which you might find useful if you go to. Yeah, so just a question there just coming on the live chat. So appreciate you guys for helping us fight for rights, because all this is to do with rights, not law. So yeah, so I mean, I guess rights and law kind of go to, yeah, they're kind of, well, I can't think of a situation where they're not kind of the same thing really. So your rights, or many of your rights, certainly the rights we talk about tonight, come from law in some way, whether it's the Housing Act or whether it's whatever, the Care Act, or Human Rights Act or whatever. So the rights that I'm thinking we have, I mean, okay, yeah, it goes back to the British Constitution. I think all of the rights we have come from law. So yeah, in one sense, understanding law would kind of then help us understand what our actual rights are, if that makes sense. And again, if you guys want to add anything to that, because it's a bit different from like America, where you've got like the Constitution, like you kind of got right to bear arms and stuff. We don't have anything that's exactly the same as that. Some people say we should have, but yeah. Yeah, cool. So, how you right, B Smith? How you right, Cheeseface? So next question in the chat, which is anonymous, so thanks very much, much appreciated. No, not that one. I'm gonna get there in a minute. So, do the LGO have to investigate everyone's complaints, or can they refuse straight away? Good question. So the LGO is the Local Government and Social Care Ombudsman. They won't investigate every complaint, so they'll turn down certain types of complaints. So for example, if it's a complaint which is out of time and there's not a particular reason, then they'll consider whether they should exercise their discretion and investigate, but they might say, actually, there's no good reason for us to kind of look at this out of time, therefore we're not going to look into it. Other times they'll look at the kind of complaint and see if there's any kind of actual allegations of law breaking itself. And if there isn't, then they'll just basically discontinue their investigation. And the other thing they definitely won't, it doesn't seem they'll ever investigate, is where you had a right to go to challenge it through the court system or through the review process. So for example, if you went to the LGO and said this non-priority decision was rubbish, they didn't look at the right things, they didn't they didn't do it right, then the LGO wouldn't form an opinion about that at all. They simply say you should have gone down the Section 202 review process and we can't comment on it, because often the LGO is not looking at whether the council got it, the actual decision itself, right. They're looking at whether they followed the right process to arrive at the decision. So yeah, so they will sometimes basically just not kind of take a complaint further. But if it's within the time scale, if it's like a substantial complaint in the sense that you're raising real issues and that kind of make sense, whatever coherent issues, then they will investigate. And they still may or may they may not uphold it even at the end of the investigation, but they won't do a proper investigation if those kind of initial criteria aren't met. So hopefully that's makes sense, even if it's not particularly helpful. So yeah. Right, so next question that's coming through the week, and I'm going to do actually a video about this one because it's a really kind of common question. It's quite difficult to explain. So I'm going to try and explain it here and see if between us we can come up with a better answer than what I can. So does homeless place you as emergency priority automatically? As my homeless caseworker and housing officer said, I'm emergency priority, yet when I called the council housing, they said I'm basically standard homeless, nothing additional, although I'm supposed to have 2 priority needs. So in one sense, this question, I think, stems from the fact that there's some very confusing language used within Part 6 and Part 7 of the Housing Act. And this sounds very tedious, but it couldn't be really more important. So within the Housing Act 1996, you've got 2 parts which are relevant if you're in housing need. One is Part 6, where you just apply directly to the housing register. However, if you apply for housing assistance and you might be homeless or you might be threatened with homelessness, you should immediately be dealt with under Part 7. Now, Part 7 has this term priority needs. That's the same across England. So, are you pregnant? Have you got kids? Are you vulnerable? Those kind of things, which we'll often talk about on this channel. So that term priority need is specifically Part 7, and it's always within the context of a homeless application. However, under Part 6, councils, first of all, can have their own policies, and secondly, they will use terms like priority points, priority banding, medical priority. They'll use lots of different terms or sort of iterations of the word priority, but they're not talking about priority needs. So I think what might be happening here is that the person has been found to be in priority needs. So they've main housing duty accepted, main homelessness duty accepted. They're then placed onto the housing register because everyone who's got main homelessness duty accepted will be should be put on the housing register until they're housed in one way or another. They might still get private housing, but private rented, but they still have to be on the register. And then at that point, there's like this kind of local policy that kicks in. Obviously, we can't like go through without knowing which council it is and without researching that particular council's policy. But yeah, I think that's what might happen here, because one sense you've got your homeless worker, so you've got your homeless caseworker is almost certainly in a different team from the council housing team, the housing register team. It'll be called something different in every council. So I think that might be what's happening here. So you might have two priority needs in the sense that you might be pregnant and you might have dependent children, but that's not your priority needs black and white. You either have it or you don't. So you might be in priority need for more than one reason, but you're still in priority need. It's no kind of better that you might have 5 different reasons why you're in priority need, but you're still you're just in priority need. Whereas whereas kind of when it comes to your actual banding, it will depend on other things, and councils vary massively in terms of. I think Buckinghamshire Council, they'll give you band D if your main housing duty accepted, whereas a lot of councils will give you band A or B. It just depends on the circumstances. And even so, some councils will have homeless applicants spread across 3 different bands because there's other things coming into play, like do they need mobility? Do they need accessible housing? Do they have children with additional needs? Kind of other kind of ways of kind of discerning priority status. But so I think that's what's happening. I think that's what this question's kind of getting to. But I don't know if you guys have got a different reading from me or anything else to add to that, but I'm hoping that at least made sense.
And I'd just say that in terms of homelessness, the term emergency priority doesn't really mean anything. It's not recognised as part of Part 7. There's priority need, and I suspect, and I may be wrong, but I suspect the homeless caseworker said you're in priority need. And that's why you're talking further on about 2 priority needs, and you may be in priority need for 2 different reasons. So being in priority need doesn't make you entitled to be housed treated as an emergency under the housing allocation scheme. And in fact, as I think I say quite often, the allocation schemes are often designed to keep homeless people from jumping the queue, which was happening before, so that the only way you could really get housed was become homeless. And so they'd say, if we can house you under Part 7, i.e. standard homeless, you're not going to get special treatment for allocations. And the sort of people that would get special treatment for allocations, if you look in the emergency priority sections, it tends to be people who are already social housing tenants but need an urgent transfer or something like that, which is odd because that makes them homeless. It's a really difficult to do, because you could say, you have this problem, you have to go to the council and say, can you help me? I've got this terrible problem, but please don't treat me as homeless, except for the purposes of assessing my needs, which I want you to do. I think really nowadays, unless you've got a physical disability, which means that social housing is the only form of housing that's likely to result in you getting the adaptations you might need for a property, I'm really sorry, but you're not really likely to get social housing. In the London area, if as Mike's been saying with the research, if you're outside London, you've got a much better chance. But the chances of applying to Kensington and Chelsea, say, although it does happen, I knew somebody who applied to Westminster City Council, I think it was, and he ended up in a flat, which is, where Battersea Power Station is. On the other side of Chelsea Bridge from there's a beautiful building, block of flats from the 19th century, and he got a flat in there. And I said, this has to be the most lucky application I've ever seen. But it's just pure, it's like winning the lottery, unfortunately. I'm really sorry if that sounds negative, but I hope that answers your question, that being homeless wouldn't give you emergency priority, and it'll probably actually be prejudicial if you've been recognised as being homeless to your actual chances of getting housed under the housing register. Does anybody disagree with that?
No, that's you're right. I mean, in a moment I'll come to the research I've been doing, so I've got some more stuff. But Karis, you want to add anything to that one?
I would just say get them to clarify. You can write to them and clarify what they want, and anything you put to them, put in writing and document what you're sending, and they're sending to you.
Yeah, yeah, cool. I mean, yeah. So, I mean, there's just another question coming there. Well, in fact, there's a couple of questions there. So, and I'll put this into the chat in a minute. So, someone's saying, how hard is it for homeless applicant, a single male, to find council flat? And then next one, 10 months still in TA, heard nothing from council upon rehoming it. They know my health is so. Yeah, so I'll come. There's more question to it, so we'll come back to those questions properly. But if I just go and share the screen, and I've now got up to about 200 responses from councils. So this is the FOI at every council in the country, and I've asked them what's the average waiting time in days between someone having the main housing duty accepted and then getting then leaving the housing register. So it's kind of a proxy for how long it takes to get housed. So this doesn't necessarily mean that people are going to get social housing, but it's a good indicator, I think. And I'll kind of just scroll down so you can kind of pause the screen and have a look to see if your council's on there. But I'll kind of draw some kind of noteworthy stuff in a moment. I was going to get through it, just kind of so you can pause it. So the numbers are days unless it says otherwise. So M is obviously months, Y is obviously years. But yeah, I'll do a proper video about this at some point. But so let's just answer your question. So how hard is it for homeless applicants for a single person to get social housing? Well, in Ipswich, just picking on them, the average waiting time from the point of having the main housing duty for a single person. So this is one bed, by the way. This first column, this column here is one bed. So in Ipswich, the average waiting time, according to them, and I'm assuming I'm going to take it at face value, is 21 days. Whole City Council, 75 days. But then if you go to Lambeth, 1,756 days. What that's like 5 years-ish, 6 years. But yeah, 5 years-ish. That I don't know what's. I'm trying to look for the most ridiculous one. Certainly, if you're in which one was it, Kingston? So if you need a 4-bed in Kingston, the average waiting time is 84 years, which just means nothing. But you can kind of see if nothing else, you can see the variation between different parts of the country. And Will, I guess you work predominantly within London, and so it is all pretty bleak in London. Although even in London, I think what was it? One of the H's like Harrow or Hounslow or something. Hillingdon, yeah, Hillingdon, 169 days. However, this does not mean that the vast majority of people are getting housed in private rented. So although the waiting time might be that amount, most people will be ending up in private rented. And with Camden as well as a good example. I'll go up to Camden, which I haven't put it now. Oh, sorry, hold it down the bottom. So Camden's here. So they gave the number of allocations in each category. So although the average in Camden is 639 days for a 1 bed, there was only 2 allocations in the whole of the year. So only 2 people got social housing. So the average of them was that number, but everyone else is getting into private rented. So when I've kind of got more of the responses back, and I'm not going to get all of them because some councils are just difficult, but when I get as many as possible, I'll do a video and I'll go through the kind of the findings, so to speak. But if nothing else, these kind of act as indicators. I think if nothing else, it's not foolproof. There are some caveats with it, but they do indicate. So again, even like Surrey Heath, which is fairly close to London, a 35-day average for single people. So there's, you'd be surprised is what I'm saying. It just depends where you are. So it is a lottery in that sense as well. But yeah, I appreciate that doesn't actually answer some of the questions that have come in. So let me just get the questions that have come in. So where do we get up to? Right, good question here. Are there any circumstances in which you can skip temporary accommodation and go straight into social housing? So yes, it's quite unlikely. And again, it's going to vary massively whereabouts in the country you are. So, because one of the things that is kind of worth talking about, and there's a little bit of detail, is it because you can make a homeless application quite early on in the process. So let's say you've been given a valid Section 21 notice. So, you're threatened with homelessness when it's about to expire within 56 days. So that can actually get you onto the housing register straight away. Now, in some areas up in the sort of north, that in itself might actually give you a reasonable prospect of getting housed. It just depends. So it's possible. It's not likely, but it's possible. But then you've also got people who will elect to although they've made a homeless application, they're going to choose to stay with a family member in the short term rather than moving into temporary accommodation. So that could again result in you actually a council do their inquiries, issue a decision. You're on the housing register with a relatively high banding, and you stay with your family until you actually move into TA. I remember a case I worked in Bedford where it was a family of like mum and 2 kids, and Section 21 served. We got the homeless application made and kind of everything run through, and it took the landlord 4 attempts to get the Section 21 to actually be valid. So it kept going to court. We kept pointing it out, get thrown out again, start again. And actually that bought us enough time to get her straight from her, her private rented flat into social housing. So she never had to go into TA at all. So that can happen. I'm not saying it's likely, but there are situations where that, you can get social housing much sooner. And I mean, it's basically much more likely to be the hard to let property. So hard to let is just code for like places no one else wants, but technically still social housing. So, if you just want a roof over your head, that's social housing, then actually that can work out quite well. But it will vary massively around the country. And you can never guarantee getting social housing. As Will says, the only kind of characteristic that's likely to massively improve your chances is having a mobility issue, which means you have to get properties that are adaptable, because most private landlords don't like it being done in their properties. Shannon?
Yeah, so that's where I've seen it, where I had a client who was waiting for a bungalow. And so they stayed in unsuitable accommodation. So they were homeless. They made the homeless application, but actually it was more beneficial for them to stay where they are, because they'd already sort of gotten used to the layout and everything else. So they were making do, and we just made sure that the council didn't forget them. Then they went straight into social housing with the bungalow, and again with supported accommodation. So trying to move people out of supported accommodation, sometimes you can do that and just go straight into social housing by getting them, like you say, on the housing register and staying where they are for the time being.
Yeah. I mean, I'm just thinking like in just terms of like the variation around the country. So although where me and Shannon are as Bedford, we're relatively close to London. We're also the districts in the I think in the whole of the country, which is we're certainly one of the most one of the kind of fastest growing districts in the country in terms of house building. So it's pretty common. Most people I've worked with have ended up in social housing, new build social housing. So one says I'm kind of the other end of the scale from Will, who works in London, where it's pretty grim. So you're somewhere between those two kind of extremes. So yeah. And any last orders on that question? I think we've kind of covered it. Which brings us on to this one here, number 6. How hard is it for homeless applicants single male to find a council flat? So I'm hoping those stats which I'll put up in the Excel sheet are useful. But yeah, certainly it happens. It will just vary massively. So I don't know, you don't need to put what local authority you're from, but I think how close you are to London is probably a good determinant of how likely that is to happen. I mean, and just to make the point, so you can get social housing as a result of having the main homelessness duty go to, but you can technically also get it when it's within the relief period. So it's called a final Part 6 offer, which you don't get any choice over, and it's even more likely to be a hard to let property. But again, it's still social housing, so you've got to weigh it up and work out what you want to do. But rejecting a Part 6 offer is kind of like an end game for your homeless application, unless you can show why it's unsuitable, which is quite difficult to do. Like that's the end of your options. So yeah, sorry, I'm not sure we can be any more precise in that in terms of kind of giving an idea. Oh man, my daughter's just come back from trick or treat and she's hyper. So sorry if you can hear some background noise. There's about 10 of them downstairs. Yeah, so there's a question. Okay. I'm just going to ask that person who's asked that question about 10 months still in TA. Could you just rephrase that so it's kind of in the third person, or just ask it as a what if question? I know you're being pedantic, but yeah, it just makes our job easier, and it just means you actually get better information. Yeah, so just someone's asking about that link. So I don't know why you couldn't see it. I thought it was on the screen. I'm just going to check. I thought yeah. So if if you rewind to about 6 minutes ago, it is on the screen. But when it's kind of when I kind of get all the figures back, or as many as I can, I'll probably, I think Will put it up on his website.
Yeah,
And I'll do another proper video about it, going in more detail. So at the moment, as I say, it's kind of that's the best I can give you at the moment in terms of those figures. Yeah, so we'll wait for that person to rephrase their question. Next question here, I think, is this one here, which says, does one bed include living rooms? So it would just depend. It just depends on that. So some flats will have a living room, a separate kitchen, a bathroom, and a separate bedroom. So you'll notice within that Excel sheet I shared that some councils gave data for bed sits. Now, not all councils, it seems that they have bed sit properties in the same way a lot of councils don't have 5-bed properties. But yeah, so I mean, I would consider a bed sit to be like where you've just got like one living room, and which is the bedroom as well. But I don't know if there's actually a legal definition of that, or how it kind of is defined. Yeah, and just just that question about that Excel sheet again. So unless it says otherwise, those numbers are in days. So the figures are for days, but where it says like 18M, that's 18 months, and if it says 7Y, that's 7 years. So if it's just a number, it's the number of days, because that's actually the information I requested. They gave it in different ways sometimes. Oh, yeah, by the way, guys, if you haven't already, I'll just do the YouTube stuff. If you want to just like the video and give it a subscribe, that'll be yeah, help me out anyway. And by the way, when I do post that video, I posted a good video about those waiting times when I finally kind of get the figures. And I'll ask you guys again, but when that's published, if you ever happen to be in a Facebook group where people are asking what's the average waiting time, a lot of the people who run Facebook groups hate that question being asked. They're like, oh, this is like the 100th person who's asked this question. It's like, well, it's still a good question, but just share that video to them. Just kind of give them the best information they can get. Hopefully it makes sense. Right, so let's get back to the ones from the week. So question 8 is, what do we do if the council refuses to make reasonable adjustments for a disability? They refuse an autism support worker's letter and an official diagnosis, and instead ask for a GP letter to give a video conferencing appointment instead of an in-person appointment, and the GP letter would take 21 days and a fee, which might not be possible for the claimant. What can be done? A lot can be done. I'm just not quite sure how you get there, because I know, so me and Will and Shannon have done training with Dowrick Street Chambers on the Equality Act, and they are like, kind of at the cutting edge of what can be done. In one sense, it sounds like you can get some very significant compensation or damages payments or whatever. But in terms of how you get to that point, again, I'm going to lean on Will and Caris. My guess is you need to get a solicitor first, and then you guys would be able to instruct a barrister. Is that correct? I mean, there are some other things that anyone could do, which I'll come back to. But how does that work in terms of, for example, if someone came to you with a case like that, Will, what would you do?
I would probably say to make a complaint, because I'm assuming here that the adjustment they want is a video conference rather than an in-person appointment. And
or vice versa. Yeah.
Yeah, and it's not going to be worth going to court over that, I don't think, because they're not saying we're not going to help you. They're just being awkward. And so I'd have thought a complaint to a manager might result in them saying, yeah, okay. I mean, it should really be enough for you to say that I've got a need for one or the other appointments, and to give them that. I mean, it's not like you're asking for anything particularly outrageous. So I think a complaint, because by the time you got to court, the time would be up. And the video, sorry, the doctor, they said they want a report from a doctor, which requires a fee. Now, the council should be paying that fee if they want to get a report from a doctor. They shouldn't require people to provide evidence which they have to pay for. So I would say a complaint. But where people fail to make reasonable adjustments in a wider sense, in terms of tenancies and things, trying to think of a good example. It's sort of escaping my mind now. I don't know, a reasonable adjustment might be where somebody has a hoarding disorder and the council have to make a reasonable adjustment to try and help them to, or the landlord, public landlord has to help them to deal with it rather than treat it as a breach, a deliberate breach of the tenancy. So there is quite a lot of scope for challenging failure to make reasonable adjustments. The most obvious ones are obviously where somebody can't get access because of a physical disability, that you need to put a ramp in or something. But I think in this case, you're just dealing with a housing officer who appears to be um, saying no, just being awkward. So I'd have thought a complaint saying I've got a member of the family who's autistic and therefore I need X, Y, or Z. That should be enough, really, and hopefully a manager would spot that and could see that a more serious complaint might be coming if it goes higher. So that's what I would say. So, sorry, it's not particularly. I don't think I could leap in the Batmobile and go off to court, sort of thing, on that one.
Yeah, well, well, yeah, but you could see that, Will. Karis?
I would say you want a reason for their refusal. So why have they refused to do a video conference appointment instead of an in-person one? Ask for the reason for the refusal and then emphasize the Equality Act, and highlight your diagnosis there. They're willing, the GP is willing to, but you have to provide the fee, and that's not fair on them. So go through that stages first before any Batmobile in the court thing. So you're emphasizing what is the reason for your refusal, the Equality Act, and you're requesting because you're disabled, and the GP is willing to back it up before you go any further.
Yeah, cool. And I'd also argue that a letter from an autism support worker, and whatever an official diagnosis, where that would be, whether that would be like an old historic GP letter or something, or some other kind of document like that. There's no reason to kind of dismiss that. That would immediately put the council in a position where they reasonably know that that person does have a potentially have a disability. I mean, no diagnosis automatically means you've got a disability, but it's just it's about how it affects you, but it's likely will do.
Do
So
you have,
so that's something the LG. Oh, sorry, Karis.
sorry, I was just thinking, as your autism, do you have advocates that specifically help with charities that help people with autism advocate for themselves? So a charity that would work with you advocating for your disability in your area.
Yeah. And someone like a CAB would probably be a good place to actually find out if there are specialists. I mean, so example, in Bedford, we've got Autism Bedfordshire, which kind of specialises in supporting people with autism or family members as well. So it's not an uncommon sort of theme to find in local charities. So yeah, so Leonard, I think you lost the connection there. I just asked you to rephrase your question. So at the moment you've written it kind of in the first person. If you could rephrase it as a what if question, that just helps us out. I know it seems like I'm being pernickety, but it just elicits better answer from us. It means you don't have to put your data up online and stuff. And there's some other reasons as well, which just helps us kind of refine what it is you need to know from a legal point of view, because often people's situations are a mix of very kind of highly emotive issues, personal issues, sensitive issues, and then a legal issue, and we can really only help you with the legal bit. So it helps kind of like draw that out in the situation. So hopefully that makes sense.
Could I just say, sorry, could I just say one more thing on this autism support thing? I think this has got more to do, and I made this clear, and I won't go into great detail from my previous answer, but I think this has got more to do with just a bad attitude from a housing officer. And I'll just give you an example of something I dealt with yesterday, which shows the same sort of thing. That sometimes if you're getting into a dispute about something or you're making demands of a housing officer, they will go into sort of, oh no, can't do that because. So yesterday somebody was telling me that they went to view a property, which by the time they went to view it was too big for them because their daughter had moved out, and so was no longer part of the household. And when they said this to the housing officer, they were told, "Oh no, we got to see their tenancy agreement before we can consider whether they're living with you or not." And I thought that's ridiculous. I mean, who said she's got a tenancy? She could have just moved out. But it's just that sort of thing that make it difficult and sort of, we have to have a tenancy agreement. And I just thought it's just some bad, they're just flexing their muscles or, trying to be tough. And so I think you just got to make a complaint about that sort of thing, or just see it as part of the territory. Sorry, that was my last little
Yeah, no, that's cool. Yeah, yeah, it's a very real kind of battle in terms of dealing with the bureaucratic mindset. Yeah, cool. So next question, as well, it's just a point really, so it's a good point. So some just saying that they obtain medical information from a GP just using the free, well, the using it, I guess, probably more likely the subject access request rather than FOI, although they're basically the same thing. Yeah, and so you can also get your, if you're signed up to the NHS app. So Shannon put me onto this. So if you're on the NHS app, you can basically get everything you want, and I think it's getting even better soon. So you have even more access to data. The only downside with that is that it's not actually the records in themselves that are often what you need. Although in this case, it would be what you need because you can show the diagnosis that way. But often, what you really need is a doctor or a medic to actually give an opinion about what would happen to your medical issues if you were homeless or if you had to live in a certain type of property or something. So you wouldn't necessarily have exactly what you want from the records, but it's certainly helpful. So yeah, so and I think it seems to be about to be made even more accessible. So yeah, yeah, so it's a
But
good point.
potentially there is an area for, so like some mental health services are signed up to the NHS app, like community mental health, and they can put care plans. And so there is often spaces on, depending on the area and depending on what their care plan looks like. But I've certainly seen care plans where it talks about actually your housing or what that might look like. So if you're, it's quite common, don't we? We got lots of people with mental health issues who are sort of struggling in that area. So potentially that's a way to get that as well. But I think I just want to echo Will's point a little bit as well, because there's a few questions and I've sort of stayed quiet because I'm just like sighing. Like the one around the language, I'm like, is that done on purpose? The fact that we've got 5 different ways that this language, like priority, need, and everything else, like it just feels. And then this one, like the duties on the council to find this information out. You don't need to have a diagnosis to have a disability under the Equality Act and to be protected under the Equality Act. Like we use the word protected under the Equality Act for a reason. It's supposed to be a collaborative thing where the person's involved, and I just don't. I'm struggling to see the logic when housing officers sort of treat people like this, because you're not setting them up for like a long-term belief in the system. Do you know what I mean? Like you're setting someone up to be like, oh, I'm not believed and this is the way it works and everything is against me, rather than being like, oh my God, they were really helpful and they believed me with this and they're gonna, and I'm not saying like, jumping through, whatever, but it just feels like a lot, doesn't it, for people like to try and get their basic stuff. And I know this is what we deal with every week, so I'm probably just being in a bit of a negative headspace, so apologies. I just feel for people at the minute because it should be so much easier than this, right?
Yeah. Specifically designed to be straightforward and for the council to essentially to worry about all the detail and not for a homeless person too. Cool. Next question has come from the chat. Can your banding go up if you've been in TA over a period of time? So it can, but not because you've been in the period, not because you've been in accommodation for a period of time. I've never seen a housing allocation scheme where your banding would go up just because you've been in that situation for a long period of time. But let's say you develop a health issue whilst you're in TA, or you have a kid, or whatever it might be. If your circumstances change, then yes, your banding can go up, and it can also go down, I guess, for the same reasons. So it can change, and I guess you need to make sure the council's made aware of any changes as soon as possible, and make sure you get proof that you told them. But I don't know of any. I can't think of any housing allocation scheme. So that's the policy that dictates how these different councils work within housing registers, where just because you've been there a long time. The only way I guess it would work is, let's say all 4 of us were on band B, but I was awarded band B on the 7th of January, and then Karis was on the 3rd of March. Although we're both band B, I would kind of beat Karis to a bid on a property because I've been on band B longer. So I guess in that sense, being on the band for a longer period of time does increase your chances of getting somewhere. But I don't think it would, I wouldn't get band A because I've been on there since January. There might be a council out there that does like that, but I don't think there is. So Yeah, although I guess it goes back to this whole idea that temporary accommodation should be suitable. And so if you're going to be stuck in temporary accommodation for many months or many years, it, for all intents and purposes, it should basically meet the needs of a household that's in accommodation for many years. So, although it's okay to kind of stick someone in a hotel in the short term, that's not going to be the case in the long term. It needs to be like a home. And you will have, um, families who are subject to the benefit cap, where they kind of get trapped in the system because of that, because reasons I won't go into. In effect, once they get their TA, they can be expected to be in their TA until their benefit cap comes off, because their kids leave home or because they are no longer subject to the benefit cap for one reason or another. So yeah, that's something that I guess is just a reality. Yeah, as we saw in Kingston, you waiting 87 years to get a 4-bed. That's lot longer than having an assured short-hold tenancy.
Think also, if you're potentially gearing up to be in TA for a long time, obviously it's worth checking your local allocations policy. Um, but if you are that, I don't know what it is. Maybe it's just the year and or the time of year. I've come across like 3 or 4 councils that are currently reviewing their sort of allocations policy. Um, and so if you are going to be somewhere for 3 years, often these policies are renewed sort of every 2 years or whatever it might be. Um, feed back into that consultation, like see if there's a way you can feed back and say, actually, I think X type of person should be in band A and not band C, or like whatever it is, it's worth doing. So yeah, I don't know if it's just a time of year thing or if it's just these like 3 or 4 councils, but it's worth having a look if you're going to be stuck in TA for a while to sort of have that bigger impact, I guess.
Yeah, cool. So next question. So the penultimate question that came in through the week. So number 10 for us tonight. Okay, so I did, and if anyone's wondering why these are in the first person, it's because they've come through the channel, so you can't see who it came from, whereas you can in the live chat. If that's, again, people might be thinking I'm probably weird, but this is why I can do it this way. So number 10, I did complain after the complaint, they accommodated me, but they changed my band from the highest band to lower band, and they provided the lowest possible service, I think they're saying. The first complaint response included misleading information. After that, I was disappointed. I said to them, I don't want to do stage 2, because at that stage 1, they put me down. I think that's talking about in terms of banding. Now I have a record when they called me at the first stage, they say something that I've not said. Do you think I have to send the evidence for the complaint team or not? If I send the record to the complaint team, has it a negative effect on my case again or not? So good question. There's a few moving parts here. So one of the moving parts is the idea that if you complain, you'll get like almost like a retaliatory action from the council, like they'll just be annoyed, they'll just be horrible to you, basically, which can happen. But in terms of them lowering your banding, that in a sense is something you might want to challenge in its own right, because if they've lowered your banding, there's a policy which is set by the council which they apply the banding with. And so I would say it's unlikely that it was the complaint that led to the banning. I guess what it might have done is they've got an officer to look over your situation and realise that maybe you actually qualify for a lower band. But so on the banding issue, I would say the answer is go and check that your banding is correct, and if it's not, go and appeal it using the council's kind of own policy and kind of instructions of how to do it. So that's in fact, anyone else want to come in on that first element of the question? Because I'm about to go a bit further, but rather than kind of lose it all. So yeah, okay. So the next part of the question. So the person didn't pursue stage 2 because of just how they were dealt with at stage 1. But now they've got some kind of evidence, which kind of like smoking gun evidence, I guess. And so should they kind of do anything with it? So we can never know for sure. There's always a risk that you make a complaint and you'll get treated worse because of it. But what I would say, before we even kind of get into it, is the first stage complaint will always be perverse, in my experience, bar one. The first stage complaint will always just be ridiculously, cynically just wrong, and kind of they will never uphold anything significant. That's just because a council worker in that sort of position is a certain type of person, I guess, that can sleep at night doing that. So the second stage complaint is always going to be more, it's going to be dealt with more reasonably anyway. The first stage complaint, they're just hoping you go away. So this is a great example of it. They've given you a really negative first stage response, and you've given up. And so I'd say don't give up, take it to stage 2 anyway. And then the third part of the question is you've got some kind of record, like a recording or something about that proves what the council's saying is wrong. What I'd say is it would depend how substantive the issue is. Like if it like completely changes the nature of the complaint. So for example, I remember I worked on a recording 10 years ago nearly where the client spelled out the medication they were on. So told the housing officer what health issues they had, even went to the trouble of spelling out the medication, and the housing officer wrote it down. And then in the complaint, the council officer said he never mentioned his medical issues. And I was like, we've got a recording, you dickhead. Yes, yeah, we're going to go with that. So I took that to the LGO, and the LGO accepted the audio recording. But if it's not that substantial, if it doesn't change the substance of the complaint that much, then I would say, it's more important that you actually take it to stage 2 rather than the fact that you feel like you've got something which kind of catches them out. As difficult as it is, and this is, it's very difficult indeed to do a complaint for yourself because you only get to do it once, and so you probably learn a lot from doing the first one, but then you never get to use it again. But I would say, as much as you can, you've got to get away from the idea that writing a complaint is getting back at a particular housing officer, or kind of, you might absolutely be justified in hating the housing officer, but kind of the complaint is about getting a resolution more than it is about getting justice. You won't really get justice from a complaint. They're not going to undo the damage they did. But what you might do is you get them to actually go forward in terms of a way which is going to end up in a better situation for you. So I don't know if that answers I hope that answers the question. Have you guys got anything else to add to that, Shannon?
I just want to reiterate your point really about also whether it's worth complaining about it, in terms of like they've said something that you've not said. Even if it like feels really important and it's like potentially really emotive and it's wrong and potentially triggering, like I've been in situations where actually I'm like, that's not what I said, and even that itself can be quite like, do you know what I mean? I think it's probably only worth complaining about if it's directly relevant to a decision being made. So even if it's something like, I don't know, they've got some family set up example wrong, but it's not having an impact on anything to do with your housing or anything like that, it could be really emotional for you. And it could be like, I didn't say that about this situation. Like, why have they put this down? If it's not relevant to any decision or any outcome, you've got to focus your energy elsewhere in this process. I'd say, like, maybe once you're housed afterwards, you could complain about that and complain about sort of actually their data keeping practices or whatever it might be, or the way they collect data. But I just think to make that distinction between actually, like, even if it feels really important, try and like boil it down to what it's going to have an impact on, if that makes sense.
Yeah, Karis?
Yeah, sorry. I was just gonna say in regards to giving them the recording, but you can listen to it and review your evidence, and you can summarize and say, this is what happened. If they're saying something you didn't say, something you said, you can say, yes, I said it, this is what I said. So review it and go through your recording initially and go through your evidence that you've got and why it's important to your complaint, upholding your point. And definitely follow through with the stage 2, because stage 1 is designed to just go away now, and it hits you hard. But go through your evidence carefully and slowly, and take your time going through your evidence. So it's based on, you can be accurate and more substantial of what you said, or what's gone on.
Can I just add, would you have the right to rectify your information, right, under the Data Protection Act? So would they not be better off in that sort of second bit where they're talking about they've said something that I've not said? Would they not be better off using that, exercising their right to rectify under the Data Protection Act instead of complaining?
I mean, I think they could do it that way, but I'd say it goes back to the same thing we've been saying in terms of if it's going to make a substantial difference, then yeah. I mean, you could in the complaint kind of recite the fact you've got a right to rectify, but I'd say you still want to run it through the complaint system, even if you're kind of making the point that actually you want it changed on the council's records because it's wrong. So yeah, I think it's kind of, it's something else to put into the complaint potentially, but I'd still probably run it as a complaint. You can do it elsewhere, but I mean, to be if you're gonna, yeah, I mean, you can just write to the data protection officer and say there's some data, there's some information in the council system that's wrong. But
So that was
yeah,
my thinking. It was more to avoid any comeback. Like, you know, it was more to sort of like almost skip past the housing team and go straight to the data protection team. I mean, the reality is the data protection team probably then pass it on
go
to the
to
housing
housing.
team.
Yeah.
But yeah.
Yeah. Okay, cool. Well, hopefully that has answered the question reasonably well. Yeah, just someone saying in the chat, just keep all the council, do everything in an email, 100%. Don't pick up the phone to the council. I wouldn't. I'd do it all, run it all through an email. Yeah, or if you do pick up and it's they've got a withheld number to say I'm in Tesco right now. Can you email me your questions, please, and I'll get back to you, because then you've got proof that you sent what you sent. And just a question there, just about the bidding again. So I'm not going to put it into the main body, but yeah, just so it's basically there's a property with 100 bids on, and then 3 weeks later it's back on the same system. That can happen because you get like people shortlisted, and then for whatever reason it kind of falls through, or the housing association's been annoying, which happens quite a lot. So that can happen. Yeah, and then basically it's just so for whatever reason, I mean, it's not unusual for people who come like fifth or seventh in the bidding to actually be the ones who end up winning the property. It just depends on what's going on behind the scenes, which you'll never be party to. But there's kind of all sorts of moving parts, So people win a bid, then it turns out they've got rent arrears with that housing association, so the housing association refuses them. That kind of thing happens quite a lot. So that it can happen. That which brings us to our final question for the night, because it's now 8:30, which is. Again, one coming through the week. So yeah, if you're in the live chat, guys, and you haven't had a question answered, just spill it over to Will's channel on a Monday, where we'll be for 7:30 doing a similar thing to what we are tonight. So we're going through. This is the question. We're going through the exact same situation with councils, referring to a video that I put up with one of a child with a autism spectrum disorder, trying to force us to move to another yet unsuitable temporary accommodation with threats of discharge and getting child services involved to take the children. Now, the answer to this question is actually relatively straightforward from a legal point of view. It's not when you're actually in that situation, but actually what it doesn't say here, I think this family has been in a B&B for more than 6 weeks. I've already gone back to them saying, you're going to get compensation anyway because you've been over the 6-week limit. But I just wanted to kind of put this in here in terms of this kind of getting children's services involved to take the children. I know Will's got a lot to say about this as well, but that's not lawful to say the least. So if you're going to have a child removed from your parents' care, it has to be for very, very good reasons, and being homeless is not one of those good reasons. So I guess, if you're already like not meeting the needs of your child and, really kind of, abusing them or something, and you're also homeless, then yes, that might kind of tip it over. But the reality is for the hundreds of thousands of families who are homeless with children, children's services are not going to take children off. They can't legally, and also they can't afford it anyway. So I know Shelter did a campaign like 3 years ago fighting this kind of stuff that happened. And I had an LGO, I've probably talked about it before, an LGO decision where that's exactly what the client got told. And we made the complaint immediately, and the LGO upheld it and said, even though the housing officer denied she ever said it, on the balance of probability, she did say it. So complain about that sort of thing, because it's another thing which council should never do. And certainly kind of just because what they basically try and get you to do is say, if you stick around, if you don't get yourself housing, or if you don't go away, we'll have to refer you to children's services, and the inference is that the children's services will remove the children. The children's services might potentially even be helpful. I mean, they're probably going to be nothing at all, but they have got the ability to actually help people, and that will be what they would initially be looking to do in a situation like this. So children's services, I know everyone sort of gets scared and says, they're going to take children away. They really don't like doing that anyway. They don't look to take children away because for lots of different reasons. So anyone want to add anything to that one? If not, go on, Karis.
Sorry, I was just going to say social services will only take the children away if there's severe risk of abuse and there's a court order obtained. So, and it's just refer to Article 8, right, of family life, and really complain to the council about what they've said and done, because this is not just a novel. It's disgusting.
Yeah, I mean that'd be the sort of thing you'd want to have a recording of, because that would be like very useful. But yeah, it shouldn't happen ever. Cool. All right, guys. Well, Cara, Shannon, and Will, thanks very much for being around tonight. I'll be back on Will's channel on Monday, as will, I'm sure, and plus Shannon and Cara if they're around. Keep the questions coming in the live stream. As I say, if you do watch that video, which was why did council housing officers break the law so much, do consider sharing it if you agree with what I'm saying in it, because that's probably the most wisdom I've ever expressed, from my last 10 years of seeing this all happen. So I think it has got the ability to kind of actually prompt housing officers into changing their approach. But other than that, we'll see you soon, guys. Keep going with all your stuff, and I hope, I guess we all hope that you kind of this is useful and you kind of get some good results. We are seeing some people getting some good results, by the way, so it is nice to hear that people who kind of maybe had a question or two over the months in the live stream, and actually that's kind of gone on to make a real difference for them. So it's not going to do it all the time, but we're happy to hear it does sometimes help. So take it easy, guys. See you next week.
Bye.